Shri Narendra Modi ji, Honorable Union Minister for Law and Justice, Shri Arjun Ram Meghwal ji, Honorable Lord Chancellor and Secretary of State for Justice, Mr. Alex Chalk, the Learned Attorney General, Shri R. Venkatramani, Learned Solicitor General, Shri Tushar Mehta, Chairman, Bar Council of India, Shri Manan Kumar Mishra, Vice Chairperson, Bar Council of India, Shri S. Prabhakaran, my distinguished colleagues of the Supreme Court, Chief Justices of the High Courts, Judges of the High Courts, all the other distinguished guests this morning. It is a privilege to address this august gathering. At the outset, I applaud the Bar Council of India, the Law Society of England and Wales, the Bar Council of England and Wales, and the Commonwealth Lawyers Association for collaborating and putting together a conference of immense promise and relevance. Each one of us, individually and collectively, have volumes, whether it's now terabytes or gigabytes or petabytes, to learn from different jurisdictions, perspectives, and most importantly, from each other. All we need is the humility to recognize this vast scope to learn and platforms for such an exchange. The aim of the conference to promote what has been eloquently phrased by the organizers as introspective discourse and constructive dialogue is indeed noble. Over the next 2 days, we will witness some of the best minds, including judges from across the globe, my own distinguished colleagues in the Supreme Court and in several high courts, global practitioners and legal scholars discuss the diverse challenges to justice delivery. As the inaugural speaker, however, I believe my task is different. Instead of addressing specific challenges to justice delivery, I seek to present an umbrella framework to address these challenges and find innovative solutions. It is utopian to think that there will be a day when we will find perfect solutions and no challenges to justice delivery. However, it is definitely not utopian to aspire to a world where nations, institutions, and most importantly, individuals are open to engage with and learn from one another without feeling threatened or belittled. It is in this engagement that I believe lies the framework to find mutual solutions. Firstly, engagement between nations, constitutions, and legal systems. What better example than our own beloved Constitution? From the drafting of our Constitution to the adjudication of constitutional questions, India has a rich tradition of engaging with foreign constitutions and precedents. It is often argued, and I tend to agree, that our openness to draw from foreign experiences is rooted in our perception of the Constitution as a transformative document. When a Constitution is perceived as transformative, it is more likely that foreign experiences will be drawn as inspiration of how such transformation is possible on several issues. In a number of my own judgments, and that applies to my colleagues in the Supreme Court, we survey the position of law adopted by international organizations and various national jurisdictions. I have found this to be a worthwhile exercise to not only contextualize answers to constitutional questions, such as public interest immunity claims for non-disclosure, but also commercial law questions like remuneration of arbitrators. India has a relatively infant law, as legal discourse goes, the Insolvency and Bankruptcy Code of 2016. And we have drawn extensively from jurisdictions such as the UK, the US, Australia, Singapore, only to name a few jurisdictions. Knowledge sharing is, of course, a two-way street, with decisions of the Indian Supreme Court being regularly cited and relied upon by foreign courts faced with thorny questions. At the administrative level, too, the Indian judiciary must remain receptive to collaborating with various nations. India has played a pivotal role by constructing the Supreme Court buildings in Mauritius and in Bhutan. Recently, I had the privilege of signing an MOU with the Chief Justice of the Supreme Court of Singapore in the field of judicial cooperation. Chief Justices coming from diverse jurisdictions such as Kenya, the first woman Chief Justice, the Chief Justice of Mauritius, Chief Justice Sundaresh Menon of the Singapore Supreme Court have all collaborated with India and have visited us in the recent past. Indeed, nothing explains this push towards engagement across nations better than the slogan for the recently concluded G20 summit, Vasudhaiva Kutumbakam, the world is but one family. Let me dwell briefly on institutions. The next layer of my framework is engagement with institutions within the country. While the Constitution provides for separation of powers between the legislature, the executive, and the judiciary, it also creates a space for institutions to learn from each other and deliver justice. In our tendency to emphasize differences, we often forget the abundant examples of collaboration between institutions to further the interest of justice. This holds true not only in lofty constitutional challenges, but more frequently in the everyday interactions between the courts and government. Back in the 1980s, in the case of Azad Rickshaw Pullers Union versus State of Punjab, the vires of a legislation that mandated rickshaw pullers to be owners of the rickshaws they plied was under challenge before the Supreme Court. Instead of an adversarial approach, the Supreme Court and the government worked together to craft a solution. In his classic flair, a distinguished judge of our court wrote, "The state, by exercising its legislative power alone, could not produce justice until this formula was hammered out. The court, with its process of justice alone, could not produce a viable project. But now justice and power have come together, and hopefully we have fulfilled the words of Blaise Pascal. Justice without power is inefficient. Power without justice may be tyranny. Justice and power must therefore be brought together so that whatever is just may be powerful, and whatever is powerful may be just." I'm sure that the learned Solicitor General and the learned Attorney General present in the audience today will agree that this spirit of collaboration between the court and the government exists even today. I will give just one example. A constitution bench of the Supreme Court is presently hearing a challenge pertaining to whether a person holding a driving license to drive a light motor vehicle can drive a commercial vehicle under the Motor Vehicles Act. Instead of viewing the case as an adversarial challenge, the court and the government are collaborating to protect the livelihood of millions of drivers across the country. We may present disparate institutions, and our constitutional structure may place us at different ends of the table, but our ultimate aim is the same: for the nation to progress and prosper. Institutional collaboration is a precursor to solution finding not only while adjudicating judicial questions, but it also plays a significant role in increasing access to justice. The Supreme Court's E-Committee is not working in isolation, but with constant cooperation with other forms of governmental institutions. Just last week, a meeting of the Union Cabinet chaired by the Honorable Prime Minister approved Phase 3 of the E-Courts project with a financial outlay of over 7,000 crore rupees. Immediately after this function gets over, I'm meeting through to lunch with the entire team of the Department of Justice to now implement the project. The E-Courts program, being implemented collectively by the E-Committee, Supreme Court of India, and the Union Ministry of Law and Justice, is a perfect example of institutions collaborating to make justice more accessible, affordable, and transparent. The third aspect, or the third layer, is what we can do as individuals. The third and final layer of my framework is setting aside our differences and engaging as individuals in the service of the nation. When I think of this idea, it reminds me of the heartwarming friendship between one of my idols, Justice Ruth Bader Ginsburg of the US Supreme Court, and her contemporary justice, Justice Antonin Scalia. Many of you would recall the iconic image of these doyens seated on top of an elephant during their visit to Rajasthan in 1994. Despite their divergent judicial philosophies, They shared an enduring bond rooted in their love for opera, mutual respect for each other's intellect, and a commitment to justice. Just like Justice Ginsburg and Justice Scalia, there is often a variety of viewpoint and perspective between my colleagues and on the bench and me. But that is why we are a national court. However, when the day comes to a close, we come together and share moments of camaraderie. This idea of friendship beyond differences may seem light-hearted. However, it plays a pivotal role in fostering mutual respect for each other's perspectives and in acknowledging that there is always something to learn from each other. Only when we recognize the shared intention to deliver justice can we sit on the same table and find solutions. The drafting of the Constitution by the Constituent Assembly is also a classic example of engaging beyond partisan lines. Individuals from different regions of India, diverse backgrounds, and even conflicting ideologies came together to draft the Constitution in one voice. In his last speech before the Constituent Assembly, Dr. B.R. Ambedkar articulately said, "The task of the drafting committee would have been a very difficult one if this Constituent Assembly had been merely a motley crowd, a tessellated pavement without cement, a black stone here and a white stone there, is which each member or each group was a law unto itself." We find the same bipartisan effort, and this is something to which we as citizens of India must be proud, has gone into the passing of the Women's Reservation Bill recently in Parliament. The making of our Constitution is indeed a perfect encapsulation of the framework that I have proposed today. Before I conclude, in the spirit of this being an international lawyers' conference, I would like to highlight that while the judiciary definitely bears the responsibility to administer justice and uphold the rule of law, my friends at the bar, you play an equally vital role in an era characterized by ever-increasing globalization. The role of lawyers has evolved to address myriad global legal challenges. The rapid advancement of technology has created complex legal issues, with lawyers leading the way in navigating this landscape. They ensure clients and governments adapt to tech changes while upholding legal rights and regulations, covering areas like cybersecurity, data privacy, and intellectual property. Lawyers also bear significant commercial responsibility, driving economic growth by helping clients and governments enhance business efficiency and cross-border operations. Through their role in facilitating international trade, investments, and collaborations, they contribute to our nation's economic well-being and global cooperation. Just as Indian industry has radically altered its footprints from 1980 or earlier, by now reaching out across the world, I believe it's time for our lawyers to reach across the world in a global landscape. The government is in the process of creating infrastructure. There is a global outreach by the government to the rest of the world. I believe that our legal profession must not be left behind. We cannot look upon ourselves as merely domestic practitioners. Our reach, our vision, our outlook must now become global. While none of us have a magic wand to wish away the challenges to justice delivery, I'm certain that the sessions lined up over the next 2 days will inspire each of us to collaborate as nations, institutions, and individuals to find innovative solutions. With that, I come to the end of my address. I thank you for your attention. Namaskar.